Good evening, everyone. Welcome to episode 3 of our series of conversations on the Barristers model. Thank you so much for being here. We've got with us the two other speakers who are joining us virtually, Ross Prince as well as Jonathan Crow KC. My name is Gian, and I'm your MC for today. So just a recap for those who didn't attend the first two episodes. The first episode of this series, we explored the idea of whether it's possible at all to practice as a barrister in Malaysia. And I think the sense from that session was that it's probably possible. It's not, the system is not ideal, it's not optimized for it, but it's probably possible. And some people have started doing it. And then we had the second episode where we spoke about the bar for women. It's not just purely focused on women, but also on work-life balance and how do you achieve a balance between your professional goals and your personal goals. And I think the takeaway from that second episode is in order to achieve a balance, you need A, independence, the ability to choose the work that you want to do, the ability to shape your practice in the way that you want it, and B, an excellent sort of support team or support ecosystem, whether it's professional or personal. So that's where we are. And now we're in the third episode. And today's focus will be about whether barristers have an edge when it comes to court or arbitration hearings. And we've decided not to just provide the barristers' views. So here we have really a wide spectrum of people, from people who have sat as judges, people who are solicitors, and people who are barristers. And hopefully you get a big picture, both for Malaysia as well as globally, how things are, whether barristers have an edge or not. I'll just very briefly introduce the speakers. We have with us in person, Datuk Darryl Goon, who is a retired judge of Court of Appeal in Malaysia, as well as a consultant now with Raja Darrell and Low. He's also a member of the Energy Commission of Malaysia, and he also sits as an arbitrator. Prior to joining the judiciary, Darryl was a management partner of RDL and headed the firm's dispute resolution practice group. He enjoyed a wide variety of work in his over 35 years at the bar. He is a fellow of the Chartered Institute of Arbitrators and the Malaysian Institute of Arbitrators. He was called as an Arthur Barrister in England in 1980 and was admitted as an advocate and solicitor of the High Court of Malaya in 1982. And then we now go to the other two speakers who are joining us virtually, starting with Jonathan Crow KC. Jonathan was called to the bar in the UK in 1981. He developed a busy junior practice, initially in company and commercial litigation, and he was appointed first Treasury Counsel in 1998. And for the next 8 years, he represented the British government in leading public law, civil rights, and constitutional cases. In 2006, he took silk and returned to private practice with a specialization in appellate work. He also appears regularly overseas and in many Privy Council appeals. Apart from his work as advocate, he sits part-time as a Deputy High Court Judge in London and also as a Judge of the Court of Appeal in Jersey and Guernsey and in the Isle of Man. From 2006 to 2020, he served as Attorney General to HRH, the Prince of Wales, and he has been described as probably the most persuasive advocate at the bar. And Ross, who is joining us also from London, is a partner with Stevenson Harwood, and she's the head of Stevenson Harwood's market-leading fraud and asset recovery team, and has acted in some of the largest fraud and asset recovery claims, both in England as well as globally. She has extensive experience of high-value cross-border fraud cases and obtaining and defending injunctions, including freezing orders and search orders. She's ranked highly in all the rankings, Chambers and Partners, Legal 500, and has been described by her clients and peers as enormously savvy and clever, and an outstanding lawyer and ferocious litigator whose knowledge and experience bundled with brilliant strategic vision and commercial awareness allow the client to achieve the best outcome. And then we have Gopal here, who is the moderator for today. I'll pass the mic over to him shortly. A brief introduction about Gopal. He's got 30 years of experience at the Malaysian bar, has been recognized as an excellent senior counsel by the market, and is often instructed as counsel for a diverse range of commercial matters, including companies, banking, libel, and so on. and he has given expert evidence globally, including in Singapore, British Virgin Islands, and the US. And he's also an adjunct professor of law at Taylor's University. And amongst other things that he does, he also hosts Advocates, the podcast where he interviews distinguished courtroom advocates worldwide. And you can even find an episode with Jonathan Crow on it if you search on Spotify. Yeah. And Darryl, yeah. So without further ado, I'll pass it over to Gopal.
Thank you very much, Jian. Thank you everyone for being here. And thank you to Jonathan, Roz, and Darryl for agreeing to do this. So let's kick off with the topic. Barristers, do they have an edge in court? And what I'd like to ask the panel first is, and we can maybe begin with Jonathan, is this an important topic to speak about now? And if it is, why so?
Thank you. I feel sort of slightly conflicted in insisting that barristers have the edge, since I'm the one barrister on the panel. So I'm almost certainly the wrong person to ask. The one thing I have noticed in whatever it is, 40-something years, is that the London litigation market goes through cycles every so often. And when I started, I remember Margaret Thatcher was the Prime Minister and was very keen on competition. And everyone was telling me that the bar was over. And it was just a matter of time before it withered away and everything was going to be absorbed by solicitors' firms, and that there was really no place left for an independent bar. And 42 years later, I still seem to have some clients. And I think that, I mean, there was a phase in the 80s when some of the larger firms of solicitors started absorbing leading QCs to add to their, their client offering. But ultimately, the bar didn't die. And I think there are probably, in a sense, two main reasons. Well, actually, it's one main reason, but for two different class of client. The one thing, stating the blindingly obvious, is that the bar specializes in advocacy in court. Solicitors don't need to do that and don't do that, and quite a lot of them just don't want to do that because it is not the career path that they're looking for. Very large firms of solicitors which get involved in very heavy litigation sometimes need 3, 4, 5, 6 extra hands to do the advocacy work. So for very large firms running very large cases, the bar provides an external resource of specialists in advocacy, which, if the case suddenly settles overnight or when the trial comes to an end, those 5, 6, 7 barristers are not part of their overheads. They simply stop paying them because we are self-employed. So for the very large firms, we are a useful external, non-recurrent resource which can be tapped into for the specialization we provide. For the much smaller firms who don't get involved in huge cases, I think that the bar has provided a useful service, because you often have, the smaller firms tend not to have specializations in tax and employment and family and conveyancing and company law. But they have the clients, they have the lay clients. And so the solicitors firm, the smaller solicitors firms often use the bar in order to provide, again, an external resource in a specialized area of the law, which they themselves can't offer. So my impression is that the reason why people were talking about the collapse of the bar 40 years ago was because of the idea that it was somehow a closed shop and it was anti-competitive. I think history has proved that line of thinking wrong, because in fact, an independent bar provides a really useful service, whether it's to a smaller firm or to a much larger firm.
Thank you. Thank you, Jonathan, for that. Could I now turn to Roz? Do you think it's an important subject and important subject now, and if so, why?
So absolutely, I agree with everything that Jonathan has said. I think there's one other factor, which is the international nature of litigation. So litigation is becoming more and more international. There are more and more, it used to be that arbitration you were looking at within Europe, you were looking at London or Stockholm. There's now a whole load of emerging arbitration centres that are really holding their own. Singapore, for example, has become well known throughout the world, and you're obviously gearing up in Malaysia to do the same. And I think as litigation becomes very international, you have lawyers across the world dealing with each other. And so this question of whether you have a split profession or not is becoming quite important in international interactions, particularly where you have arbitrations, because a London solicitor in an arbitration will think about, will we do the advocacy ourselves or will we go to counsel? And that might depend, for example, on who your arbitrators are. If you've got 3 High Court judges, it's not going to be me standing up, it's definitely going to be Jonathan standing up. And so I think that discussion around how does the legal profession work and what is the role of a solicitor and what is the role of the barrister and what best serves the client is important in an international context where more of us are meeting in international disputes.
Thank you, Ros. Darryl.
Well, apart from the fact that I'm extremely comforted by the idea that there's someone of my vintage in Jonathan, I have nothing useful to add, and I adopt everything that's been said. Except perhaps, jokes aside, we do not have the distinction here. So in reality, I think it's a question of specialized practice, advocacy or non-advocacy, court-going or non-court-going. And from that point of view, and I think Gopal's question is it relevant? Is it an important question? I think it does help to identify for any would-be practitioner, the sort of area you want to specialize in and what are the advantages and what you can expect. And it sort of focuses your future direction, so to speak, in your practice of the law. But definitely, it is an issue that needs to be assessed from any would-be practitioner. Specialization, I suppose, is the issue rather than barrister or solicitor. It's specialization in going to court. Right?
Thank you, Darryl. I'd like to move on now so that everyone gets a sort of a granular understanding of the difference in the professions, the split profession where you have the solicitors, you have the barristers, and also the fused profession, which we have here in Malaysia. So could I begin by just asking Ros to speak to what solicitors traditionally do and how and the scope of their involvement in a case, assuming that you'll be appointing counsel at some stage.
Yes. So in essence, we do everything except for 2 things. We don't do the standing up in court, but that also involves the preparation, and we can come back to that later because I think that preparation element is one good reason for the split professions in England. So we won't do the advocacy or the preparation for the trial that someone like Jonathan will do. The other thing where we will often use counsel is freestanding advice. Now, of course, I can advise a client, and if it is a simple advice, I will do it and I won't go to counsel. But people sort of think of barristers in England as just the advocacy bit in court. There is quite an important part around independent advice where someone is not that close to the case. Now, you may say being all over the facts is a good thing, and in one way it is. But there is also a factor where if you have been involved in a case for 2, 3, 4 years, and the client is an important client and a client that you like and you feel strongly about the case, that can affect your judgment. It's very difficult then to step back and look at that in the way that a judge would look at a case who has just read the papers yesterday and he has none of the emotional background. So we sometimes use counsel for that. We actually want someone to objectively look at this, take a step back and give us a cold, hard, what are your chances of success? It's those 2 things that the barristers do. Conversely, one of the things that they almost never get involved in, certainly the lead advocate, is things like proofing witnesses, proofing experts, for regulatory reasons, really, they can't get into the detailed preparation of witness statements because it causes them difficulties then cross-examining those people. And we do all the day-to-day management of the case, the correspondence with the other party, the correspondence with the court, the taking of witness statements, the disclosure review. So in an odd way, the role of the barrister is actually very limited. It is the court-facing part and then that independent advice.
Thank you. Can I now ask Jonathan to speak to typically when you get involved in a case and then how your role evolves. And Jonathan, if you could, I'd be interested in knowing the difference from when you were a junior at the bar and now, obviously, as a leading silk in London.
Thank you very much. Yes, I would certainly start just by echoing what Ros has just said. The importance of the bar, I think the value that we give, hopefully, is both in terms of advocacy, but also in terms of providing arm's length advice. And the only sort of qualification I'd add to what Ros has already said is that because obviously solicitors live and work closely with the lay client, quite often what the solicitor comes to a barrister for when seeking advice is not actually a new perspective. It's actually just a new mouth saying what the solicitor may in fact have been saying for a very long time. But sometimes clients just sort of go deaf to their own solicitor. And I think quite often I have found, and I used to find this very often when acting for the government, is that the civil service lawyers will have been advising ministers about something for months and months and months. And the minister just said, oh, well, these are bureaucrats, I'm not really going to listen to them. So that as a sort of last resort, they go to external counsel, not because they don't know the answer, and not because they haven't already given the client the answer, but because for structural, institutional reasons, having the advice from an external advisor somehow just carries a bit more oomph. And so that sort of added value, I think it is true that we are at one remove and therefore potentially more dispassionate. It's also true that because we are at one remove and in a sense nearer in career structure to being judges, clients quite often take from independent barristers advice that they won't take from their own sort of in-house or from their solicitors. What we do is advocacy. That is, the most visible part of that is the oral advocacy in court. But I believe that written advocacy is as important. In some cases, it's even more important. Judges are doing much, much more pre-reading than they used to. And if there has been a single development that has altered the practice of the bar since I started when I was a junior, it is that far more gets done in writing and far more gets read by the judge in advance. I literally, when I started, if you went down to court to make an application for an injunction, the judge would come in totally blind to what the case is about, and you would have to walk them into it. And that was true right the way up the appellate structure. And I was talking to Sidney Kentridge, who retired at 90, he's just turned 100. He said when he first did his Privy Council appeals, the judges came in having not read a thing. And literally his first job in opening a case was to read the Court of Appeals judgment from which he was appealing. So the skill that one has had to develop over time is written advocacy, and that doesn't mean sort of flowery language and beautiful prose. It's working out it's the same as oral advocacy. It's working out what is the winning point, which points to shed, and how to structure the argument in a way that makes it attractive.
Thank you very much for that, Jonathan. Can I just ask you just to come back to Jonathan for just one moment and ask you the difference between that in your involvement on a brief when you were a junior and now as silk?
I think it's really in the nature of a case of one's practice as one gets a little bit more experienced and you get involved in larger cases, you are working with larger teams of solicitors. So the difference, I think, is that as one gets more experienced, one not only provides the sort of the bare structure of the advice, and the written and the oral advocacy, but one also participates in actually helping structure the overall legal team, and participating more in the strategic thinking. When you're a junior barrister, you are a talking head. You get instructed. The direction of travel has almost always been established by the client and by the solicitor, and you get wheeled on to do the best you can in the circumstances that have arisen. I think the more experienced one gets, and I suppose the more confident one gets as time goes on, I think one participates much more, as I say, both in making sure that the client has the right kind of team, not too many juniors, not too few, make sure the right people are doing the right parts of each case, because in any large bit of litigation, there's always satellite stuff going on. So one participates partly in structuring the team, and I think, as I say, partly in designing the overall strategy for how the case is going to be moved forward.
Thank you. Darryl.
I think the point about objectivity that's brought by counsel is very, very valid. And I think particularly so for a fuse profession like ours in Malaysia. I remember clearly on one occasion when we had given the view that on an appeal, that it was not likely to succeed, but we'll give it a shot. But by the time we went to court, I mean, we were convinced we were going to win, and then, of course, we lost. And we looked around and said, there you are. We've lost all sense of objectivity because we've assimilated all that the clients were trying to persuade us with. And we took that on board and believed in it. In a way, it was good because we were prosecuting the case as we should do. But you do lose your objectivity, and that's important for a fuse profession like ours. It's vitally important to be able to see the weaknesses of your case, apart from the strength of your case. I think that's the thing that one has to bear in mind. And the other point about written submissions, I think that is equally vital. I think most of our time spent reading. I remember Michael Balogh gave a lecture not so many years ago, tracing the evolution of advocacy in the UK. It's exact same experience we had. When we started in Malaysia in the early 80s, if you were to present the court with an outline of your submission, you'll be frowned upon and trying to steal a march. We'll just we'll stand up and say, what on earth is that? It's not on. But things have changed so much. And now, by the time you get to court, what the judges are looking for is actually satisfying themselves with the problems that they've encountered reading your submissions beforehand. So that is the important part. And I think it is a far more effective way of getting a case across, because I've read the material. Now I've got problems. Please answer these questions. And I think we get to the root of the matter far more effectively than to have the whole story being, narrated from A to right to the end, to Armageddon, I suppose. Yeah. So the written submissions is vitally important. Very often, far more important than the oral bit, because it can be made so clear that there will be precious little that the judges want to know when it comes to the oral part of it, and in a way it can be counterproductive, but that's the reality. Views are formed. It's only an idiot who doesn't read and doesn't have a view.
Thank you, Darryl. Can I just finish this question by going back to Roz and asking you this? And I'm interested in whether your answer to this will echo with the lawyers in Malaysia who are all sitting here in this room. And my question is, you're a solicitor advocate, so there are obviously occasions when you do the advocacy as well. Shortly put, what is your biggest challenge?
That's actually a really interesting question that mirrors a point that Jonathan made about things going in waves in the London litigation market. I got my solicitor advocate qualifications very many years ago, just after I qualified. And at that point in time, there was a big push for firms, particularly litigation firms with big litigation teams, to get their lawyers to qualify as advocates. And back in the day, I did do a bit of advocacy, particularly around smaller cases. So particularly as an associate, it was quite common if you had a time summons, if it's a lower level court, a master rather than a high court judge, and I would go and do that advocacy. It's now become very challenging to do any kind of advocacy because as I've became a partner and got more senior and started to do larger cases, the value of my cases is proportionately larger. And so there's a lot at stake in anything substantive, and it's quite difficult to justify a solicitor going to do the advocacy. The simple fact is any hearing, there's usually so much at stake that it's quite rare actually on my cases even to use a junior barrister. We get KCs doing most of the advocacy. There's also a cost issue on the smaller cases, conversely, because I'm now more expensive as a partner, I can get a barrister who spends all their time going to court at half the cost of the hourly rate of a law firm partner. So it does get to the point where it's very difficult on any case to find a case where it would be suitable for me to do the advocacy from a costs perspective, and critically where I could find the time. And I think this is probably the biggest advantage of independent barristers from a client perspective. If I've got a trial, even a one-day trial, I can brief Jonathan and his clerks will stop him from talking to anyone else for that week. Whereas for me to take a week out to prepare for a trial, I would have to tell all my other clients, sorry, I now can't talk to you for a week. I've got a week where I'm just going to wrap a cold towel around my head and hide in a darkened room and read the documents. And frankly, no law firm partner has just one client, or certainly if they do have just one client, something is going a little bit wrong in their practice. Most of us have multiple clients, and all the other clients are not going to be appreciating me saying to them, sorry, goodbye, I'm not speaking to you now for a week. From a pure practicality, the split profession in England allows Jonathan to do what he does best, which is really focusing on an upcoming hearing without distraction, whilst allowing me to service all of my clients, speak to all of them without having those big gaps in my diary. And I think speaking to lawyers in other countries that have split professions, I was in Paris for the IBA recently, and I was talking to a Jersey lawyer where they have a split profession. And he's a very senior partner, and he was saying to me, he loves trials, but in reality, he now can't tackle anything other than a very short trial because it would take him out of practice. I mean, the other thing, it's less noble than the client work, but all of us also have to do practice development. We speak at events on panels when we very kindly get invited by people like you to come and speak on panels. We go to things like the IBA and to conferences, and we tend to do that as solicitors much more than the independent bar because their market is solicitors. They really only have to know us solicitors and the work will keep flowing if they're good at their job. Whereas for us, we have to go and hunt much more widely for the next case. And again, the idea of taking 6 months away from marketing and away from other clients to prepare for a trial is, in English practice, not really feasible nowadays.
Thank you for that. That was a very interesting answer. Of course, now we've got two judges in the room today because Jonathan sits as a judge part-time as well, and of course Darryl. And I'd like to sort of explore the advocate in Malaysia, the lawyer who has advocacy only as his task, and Jonathan's experience in the UK with barristers appearing before him. So can I start with Darryl from the bench? Is there a marked difference with lawyers who focus purely on advocacy and against those that do everything as a solicitor as well?
Yeah, I think the answer must be, it surely must be a difference. Yes. There must be a difference. I mean, the confidence which a barrister or someone who goes to court all the time exudes and the ability to deal with procedural points and knowing what the courts are looking for, that's all an advantage and experience that you gather by going to court very often. And I think it's not so much a question of solicitors or barristers. I don't know if anybody remembers David Napley in the late 70s or 80s. Do you remember that, Jonathan? So David Napley, technique of persuasion. Oh, come on. Yeah.
Yeah. Yeah.
Now, he was a formidable advocate. He used to do the preliminary inquiries, used to have them those days, right? And his book on the technique of persuasion was far more popular than the one by Richard Ducan, who was leader of the bar, The Art of Advocacy. And he managed it pretty well. So at the end of the day, it's really very much the individual, what you bring to it. But of course, if you specialize in going to court, obviously you're going to have an advantage. You're going to be more at home in court. And I think it's always the experience that's important. So any court lawyer, the rule of thumb is get yourself into court, make those decisions of running a case yourself. And that's always the best thing. So yes, we do, you can see that coming across. And solicitors who seldom go to court, when they appear, they tend to be very formal. They tend to go through the nitty-gritties, which one normally would assume is taken for granted. So that's where the problem is. So yes, the answer is there is a difference between court-going advocates and non-court-going advocates. Yeah.
Jonathan?
Yes, I think I completely agree on both fronts. I think that having a specialist practice in advocacy it is a permanent education. It's one of the few careers where I suspect, other than a performing artist, where you can carry on, hopefully, getting better if you are sufficiently observant and self-critical, because it is just all about experience and recognizing what is going on. And the more you do it, the better you get, I hope. Whereas by analogy, I was giving my oldest son a hard time about not getting his driving license recently, and he said, we live in central London, he said entirely reasonably, and this makes the point, he said, Dad, there is no point of getting my driving license because I'm never going to use it. So it'd be quite dangerous to pass my driving test age 21, not drive for 5 years, and then get a car and set off on the road having had absolutely no experience. And I thought, actually, that's an annoyingly good argument. And it's a bit like Ros was saying about, getting her advocacy qualification some years ago. But if you don't use it, if you're not in court, picking up on the nuances, just picking up how litigation is done. And things do change. The whole way in which English litigation is conducted has changed dramatically since the 80s. When I started, it was guerrilla warfare. It was aggressive. You took your opponent by surprise as much as you could, and you ambushed people. Now things, and it's partly one of the incidental benefits of having to produce skeleton arguments and lists of issues in advance of hearings. Things are conducted now, thankfully, in a much more statesmanlike way. Some people haven't learnt that. There are some firms of solicitors, there are some barristers who still are in sort of guerrilla warfare territory, and it doesn't work well with the judge. I mean, it is, I think, very educational to sit part-time as a judge, because you just learn what matters and what helps to win a case and what doesn't. Some people who are less experienced think that if you get into a really good argument with the judge, the client is going to think that you're fighting their corner. Actually, what you're doing is annoying the tribunal. And it's very helpful to see it from the judge's perspective, and hearing the advocacy, and as I say, seeing what works. And experience teaches you low-key, non-aggressive, stick to the winning points.
Thank you, Jonathan. Now we come to a question I think that was asked has been asked in our previous two sessions. And it is this: how does one explain to a client why you need an advocate? And this is, I'm guessing, more from places where you have fused professions. And of course, I'm sure, Ros, you go through this as well with clients who are not aware of the split profession in the UK. So can I start with Darryl? I know Darryl has used, rarely, but in the past he has used counsel in Rajaz's and the like. So Darryl, can I start with you and ask you, so how do you explain to the client why you need an advocate?
I think, to be frank, many local clients are not that sophisticated. I mean, they go by the name. I mean, we have, for example, formidable advocates who operate out of large law firms. We have people like Tan Sri Cecil Ibrahim, Cyrus Das, and all these big names, Lim Ken Chai, they come from large firms. They specialize in, they're not external counsel, but they are large names. They have acquired a reputation by just going to court and specializing. Now, the question then translates itself to, how do you convince a client to get a specialist when you are not? I mean, that would be simple enough, I think, with basically many solicitors nowadays, and it's growing in the country, in Malaysia, who don't go to court, and they brief external counsel. They brief sets of counsel like Gopal, and it's easy enough to convince the client that you, for all the points that was made earlier on, objective, someone who is practiced at the art of advocacy, goes to court often, knows how to read the judges, know how to manage themselves in court. Those are all selling points. That's not very difficult to sell to a client. That is, if you are not yourself going to court. I mean, you won't be doing that if you are.
So Roz, back in the day, Russian oligarch turns up at your desk. How do you explain to him, we need Jonathan?
It's quite interesting. The ultra high net worth individuals from emerging markets actually normally understand wanting counsel. Quite often they start with that they want the best possible and the most expensive possible person. So they're usually easy to deal with. The difficult ones quite often are the American and the European clients who have fused professions, and particularly clients that are more cost conscious. Often the initial question is, well, hang on, why are we paying for another person? The way you explain it is the points I made earlier. You say, look, I'm not going to be able to take time out to prepare for this properly. If you want someone to properly prepare your case, this is someone that we can pay to do nothing but look at your case for a number of weeks in the run up to the hearing. If that doesn't work, quite often you do the maths and you say, well, look at my hourly rate. Now that won't work with really senior King's counsel, but you often, as I say, the clients who query barristers are often the ones that are more cost conscious, quite often smaller cases. And those are often cases that you'll be going to a junior barrister who quite often will be. You can often do the maths and say, look, actually, if I were to do this, even assuming that I didn't have the problem of not being able to set aside 3 weeks to prepare for your trial, my hourly rate is higher than a relatively junior barrister. It is actually going to be cheaper for you, for this person to do it. And although they are more junior than me, they certainly have, as Jonathan was saying earlier, more court experience. So I am more qualified as a lawyer, but I've never done a 2-week, negligent misstatement trial or something. So it's a cost selling point, an expertise selling point. I don't think clients buy things like the independence of the advice, because that's probably less important to them conceptually when they're starting up. It's more, this is the person who has the expertise, who has the time.
Thank you. Can I now turn? I know we've only got sort of 15 minutes left, and I've just got a couple more questions before we open it up for questions from the audience. But can I ask you, Jonathan, this? If you were to pinpoint 3 skills that you bring as a barrister that a solicitor would not have the time to do, could you describe them to us?
I would think that the most important thing one develops, and it's really a product of all the things we've been talking about, of experience, of specializing in advocacy, and of being at arm's length. I think, if anything, and it matters most when you get to an appellate level, because clients, solicitors, and sometimes, the junior barristers who have been living with a case for a long time get invested. As Darryl said a while ago, they get invested with the case. They start seeing it from the lay client's perspective. So I would think possibly the single most important thing one brings is an eye for relevance. which is a very sort of mundane thing to say, but you win cases by identifying what is the point that's going to win. And I actually think that's if I can just answer your request for three issue, three items.
One is fine.
There is one.
Thank you, Jonathan. Darryl.
Perfectly legitimate point that Jonathan made. I mean, and that's very important. Getting to the heart of the matter and what's the relevant issue in any case, and that's the strength of a true advocate. But what was your other two questions? I forget.
There were other two. I wanted three questions that barrister brings, but no, one is fine.
Barrister.
One is
what
fine.
a barrister brings.
One is fine.
Basically, I think Jonathan has covered it. Yeah.
Okay. Let me turn to Roz and ask you this. So when you appoint a Jonathan Crowe, what do you look at and go, right? That's what he brought to this brief that I could not.
I think from a solicitor's perspective, there's different cases, and I probably can give you three things. As Jonathan said earlier, sometimes it is the specialism. I have a working knowledge of wide areas of law, but for example, I do fraud and asset recovery. And I remember a few years back doing a case that was all about repossessing a fraudulently obtained property. Now, the intricacies of English property law are not within my specialism. I have partners who deal with that, but we did bring in junior counsel alongside the KC who does nothing but property law. So there's specialism. There's, as Jonathan said, the independence. But also importantly, as Jonathan said earlier, there is that being a second voice. Hi, people are very upset. They've either been defrauded or they've been accused of fraud. Nobody is happy and relaxed. And sometimes there are decisions that are so important that actually it's helpful to have a Jonathan repeat exactly what I've said. The client's heard it once from me. There is something about the formality of the setting. I may have a conversation with the client in a meeting room over a phone, but when you have that formality of going into counsel's chambers, Jonathan sits at the front of the table, it's obvious that he's had a week to think about nothing but this issue. It sinks in a little bit more. And there are frequently, I mean, I do in fact work with Jonathan, and he and I frequently agree on points. Sometimes it's helpful to have him repeat that though.
Okay, thank you for that. So I was going to wrap up by sort of asking the panel whether barristers do enjoy an advantage in court, but I think just sort of following the flow of what all of you have said, I think clearly that is the case, and there's no need to go into that. So we've got 10 minutes for questions for Jonathan, Roz, or Darryl. Can we have some? Yes.
Perhaps this question is directed to Datuk Darryl and also Jonathan. As a judge, either at trial or at appellate court, what tips can you give for counsels who appear at trial or at appeals, given your experience in listening to different counsel, perhaps what they can do, focus on, and what they shouldn't do? Thank you.
Jonathan. You first, Jonathan.
Sorry, as only a part-time judge, I thought I might go second. But I would say, I mean, when I'm sitting as a judge, I value courtesy. We all have these words, my lord, this, may it please the court, whatever it may be. They're there for a good reason, because the only point in having legal professionals is to make sure that disputes that would otherwise be vile, acrimonious squabbles are conducted in a dispassionate and professional manner. So courtesy, I think, is vital. The second thing, that's just presentation. The second thing, in terms of content, I think that one has got to identify the point that is important for your client, and the corollary to that is deal with the point that's difficult. We can all polish up our good points. If there is an obviously difficult point, a point that your opponent is going to make, deal with it. Don't duck it. That would be my advice.
Well, courtesy, of course, but I think clarity and brevity and getting to the point quickly, I think that's important. Of course, hopefully it's a relevant point, but don't forget, sometimes it's difficult because the judges may come to the case with a preconceived idea of what the case is all about. So the idea of what is relevant may not be the same. So we have an uphill task to fight when, with the judge in those instances. But by and large, I think Jonathan's absolutely right. If you are relevant, get to the point quickly, brevity, clarity, that's it. I think that's very important. Yeah.
Thank you.
So,
yes, Jay.
So for those of you who might not want to ask in person, there are QR codes for you to ask online as well. And I'm just asking on behalf of someone who asks online, what do you do where a solicitor you're not familiar with engages you to do a case where you disagree with the approach taken by the solicitor on the case? And I suppose that's directed at those who practice as barristers. But I think it also applies maybe on the flip side where, say, you are the solicitor and then the barrister then takes a different approach that you don't agree with.
Yeah, we saw it was on that one. How do you deal with recalcitrant counsel?
Well, we have we are in the fortunate position that we instruct them. So we do sort of select people usually that we know. It depends what the disagreement is. If there is a disagreement on the merits of the strategy, then we would tell the clients. And, look, counsel's taken a different view. And sometimes the clients will follow counsel's advice and sometimes they'll follow our advice. And I think that kind of disagreement can be healthy. On difficult cases, sometimes there is no clear answer. That's one of the advantages of having counsel. They might come to a case and say, I've got a different view on this. And I've had disagreements where counsel's been right. I've had disagreements where I've been right, including as to the outcome. I've had counsel say, we're never going to win this, and we did, which was particularly satisfying. On the other hand, if counsel is just being difficult, then one does change counsel. So if there are issues around, you might have disagreements around service to the client. I have some very demanding clients who expect answers same day. And if you happen to instruct a counsel who you don't know before, who perhaps still works in quite an old-fashioned way, not quite used to the speed of instructions and responding to clients nowadays, then if the client is unhappy about that kind of service issue, then you would change counsel, and that is another advantage of the split profession.
Jonathan, can I ask you how you manage solicitors when that sort of thing happens?
Well, I think my answer is a variant on Roz's. The answer entirely depends on the nature of the difference of opinion. I think the starting point is that the client is entitled to your advice. If it happens to be different from the solicitor's advice, you need to work out the best way in the client's interests of resolving that problem. For me, the starting point is always to make sure that one has had a very clear and open dialogue with the solicitor first to see if the difference is in fact based on some misunderstanding on one side or the other. If you can achieve a consensus, fantastic, because then the client is getting uniform advice rather than conflicting advice. Sometimes, as Roz says, is actually positively helpful for the client to have different views expressed, because a lot of decisions in litigation are not really, what is the law? That quite often is the easier question to answer. A lot of the decisions in litigation are strategic ones, and there isn't a right answer. And so very often it is a judgment call on which, it's actually positively helpful to have two different alternatives, debated out in front of the client, and the client can then make a judgment call. So I don't think differences of opinion are necessarily a bad thing. They can be positively salutary in helping the client reach an informed decision. At the very bottom end of the spectrum, of course, there are differences of opinion. If I genuinely think a solicitor has made a mistake, then that is something that you need, first of all, to talk with the solicitor with and just get it out in the open, and you then do need to tell the client that. But I mean, that's happened to me about twice in 42 years. Most of the time, as I say, you either reach consensus or you offer the client the two alternatives, which generally I think is a good thing.
Thank you. Darryl, you've been on both sides of this fence. How do you manage it?
Well, I don't recall any situation where there was any disagreement as to how the case to be prosecuted or defended. It's always been the case of, if you want me to argue this case, is how I'm going to do it. And that's how I believe I'm going to do it. If you don't like that, unfortunately, you've got to find someone else who like to present it the way you think you want to do it. And it's always, always worked. I mean, we don't have that solicitors type problem. But yes, it can be a problem. I suppose if you cannot agree, you've got to get a consensus. But if you cannot agree, and there's really a loggerheads, you really have got to find someone which you're comfortable with. Yeah. But I can't recall having such a situation, encountering it. Yeah.
Thank you, Darryl.
Just railroad them. Right?
Just railroad them, right. Any other questions? Yes.
Given the importance of written submission, have you all seen the diminishing rules of advocacy, or the advocacy standard, the skill have dropped drastically?
Darryl, can we start with you on that one?
I think with written submissions, I mean, it's a form of advocacy, and that's vital. It's an art in itself. But I think oral advocacy now becomes even more, demanding, calls for greater thought, because you have less time. The bench is now au fait with the case as an idea. And to be effective, you really have to put a lot of thought in your oral advocacy and how you're going to manage the case when you're before the court. And that is if you're given the opportunity to run it the way you want to, because courts these days are more willing than they were before to actually intervene. Those days, you argue and the judges just kept quiet, and then your case gets dismissed and you haven't the foggiest idea why. And will be a year later, the judgment comes out. If it does, in the 80s, as you know, things were pretty bad. But now, no, and it's an excellent thing, development, because you get to read the judge's mind. You get to read what's bothering him. And those are opportunities which advocates, seasoned ones, will know how to make full use of. And I think advocacy actually is pushed to a higher standard, expected a higher standard, in circumstances where there are written advocacy in advance. Yeah.
Jonathan, can I ask you that same question with a slight nuance, which is this, that given how complete written submissions are today, whether it's after trial, whether it's at the appellate level, how do you decide what it is you have to add in oral submissions?
Right. Okay. So those two questions. The answer to the first one, I absolutely agree with Darryl. The fact that there is now much more written advocacy means that the oral advocacy becomes even more important and even more challenging, because very often you do go into court and the judge has already got a provisional view, and if it's a provisional view against you, you have got to be pretty powerful in order to shift them. So it really raises the stakes, and it makes oral advocacy more important and to some extent more difficult. The answer to your second question is that, in fact, what I propose to say orally, I am formulating while writing. So quite often one deliberately leaves out some nuance, some quotation, some development of an argument. You leave it out of the written thing, not in order to diminish the force of the written argument, but because you do need to have, some bullets in the cartridge when you get into court. So one is constantly taking there, and these are very, very fine. You know, one takes hundreds of decisions like this and producing just a sort of 20-page document as to exactly what's to put in and what's to hold back. So it's not that you sort of write the document and then decide what to say. You are writing the document with a view to what you are going to say. And what you have then got to do is remain in control of the hearing. Because I remember, again, I said, you know, one carries on learning. I remember doing a case I was anxious about in the Supreme Court because it was in a very specialist area of law in which I was not the specialist, and my opponent was the world-leading expert on that area. He knew absolutely everything there was about it, and it was a very interesting case. And he stood up, he had a great wodge of notes in front of him, and he got about 30 seconds into his case, and one of the judges asked a question, and he gave this absolutely brilliant answer, fully covered it, and that prompted another question from another judge. And he gave an absolutely brilliant answer to that, full of background learning, huge embedded knowledge. We got through the entire morning with him answering questions, and he hadn't turned over a single page of his notes, and he'd run out of time, and he hadn't presented his case. And all the knowledge he came to court with was, in a sense, valueless because he hadn't stayed in control of the oral argument. So what that really drove home to me was the absolute importance of remaining in control. You've got to deal with judges' questions, but deal with them in a way that fits in with the structure of the oral argument that you have already prepared.
Thank you. That's very, very interesting. We have hit 7:01 in KL, which is, I think, 11:01 in London. And I promised to let Jonathan and Roz off after the hour. I know they're very, very busy. So can we, and together with Darryl, of course, can we say thank you to all three of our panelists for a really interesting conversation this evening here in KL. Roz, thank you for doing this. Jonathan, thank you. Darryl, thank you very much for being here physically as well. We are going to have a glass of wine over here. You guys can have a coffee in London.